Hi, I'm Jeffrey M. Jacobson from the law offices of Jeffrey M. Jacobson. This is another one of our videos to help you with legal issues in Illinois. So today I want to talk about the appeal process with the Illinois Department of Employment Security. Couple definitions. There's the employer and the claimant. Obviously, you know what the employer is. The claimant is the ex-employee. And there's a couple sections. I'm not going to go into all of them. There's section 601 and 602. 601 is the claimant has voluntarily left employment. 602 is the claimant was discharged for misconduct. So those are the couple definitions that we need to know. One warning, you have to file your appeal within 30 days of the local office determination. Don't be late. If it falls on a weekend or a holiday, you have till the next business day, but I always recommend doing it within 2 weeks. There's no reason to wait the full 30 days. I just want to give you a heads up. The employer sometimes gets the local office determination. It gets mailed out after the notice to the claimant gets mailed out. So the time frame for appealing may not be the same for the claimant and the employer. Okay, so you don't agree with the local office determination and you want to appeal to the appeals division with IDES. You need to fill out the form. The form's online, or you can get it at my website at jeffjacobsonlaw.com, and I'll have the link as part of this YouTube. So you fill it out. The explanation is the only thing that's required is that you say you don't agree with the local office determination. You could put a lengthy descriptive explanation in there. Just know that you don't want to limit what you're appealing if you're not really sure what you're doing. So you're appealing the local office determination because you don't agree with it is sufficient. You also need to sign the appeal, fill out the information, who you are, your claimant number or social security number, and there's 2 ways you can send it in. One is you can fax it. The other way is you can mail it in. Regardless of which way you do it, and you can do both, please make sure you have a receipt. So make sure if you fax it in, you keep a copy of the cover page showing that you've sent it in. If you mail it in, I would suggest a return receipt on that. Okay, so you've sent it in within 30 days of the date the local office determination was decided. If the employer doesn't protest, then they're not part of the appeal process. Okay. Another thing you should know about if you're a claimant or, to apply to an employer, you can't have a non-attorney represent you. So you can't have a family member, a neighbor, someone that's experienced this represent you. Under the law, it has to be a lawyer that represented you. That's not to say you can't represent yourself. You certainly can. It is a little complex, the appeal division. Okay, you're going to receive a notice of hearing from the administrative law judge. It's going to set forth the time and date of your hearing. Typically, those are about 2 weeks out. I don't know with the COVID-19 and when you file your appeal, how far out it's going to be. Just let you know it's typically was 2 weeks, maybe 3 weeks out for your hearing. Your hearing may start later than the time on the notice of hearing, and the administrative law judges does hearings are typically every 30 minutes, but if the hearings before yours go long, and some of them can go for hours, you need to remain available. You will be called that day. Typically, if they get a little too far behind, someone else will contact you to do the hearing. But you need to make sure whatever phone you give, you're available for the hearing, because if they call you and you don't answer, you're considered in default. Now, a lot of the administrative law judges will call a couple times. but they don't have a lengthy period of time to keep calling you. So make sure whatever system you have is working. If your cell phone is run out of power, that you'll be found in default. Okay. So here's the process for how it's going to go at the hearing. The administrative law judge will explain the process, start off with the case number, where it's being heard, who's present, going through your due process requirements. They will then swear in all the witnesses. Depending upon whether it's a 601 or a 602, remember 601 is because the claimant involuntarily left, 602 is because of misconduct. If it's a 601, the claimant will testify first as to what happened. So it may be a 601, meaning involuntarily leaving, and the claimant's testimony was they were fired. That certainly happens. But the claimant will go first with the testimony. If you have any documents that you want to present, the notice will set forth the number you're to fax those documents to. You need to also mail those documents to the other side. So if you're the claimant and the employer is participating, you need to make sure you mail the documents to the employer at the address on the notice. You need to fax them to the administrative law judge so they have all the documents. The issue for whether it's a 601 or a 602 is what was the last event that happened. So you don't need to submit 5 years of appraisals that you were doing a great job. The employer doesn't need to submit, years of attendance and problems, because it comes down to what was the last reason. So most of you during the COVID-19 is because you're going to have to stay home because of COVID-19. Either the employer was closed or you had daycare issues, but it's most likely going to be under a 601 that you voluntarily left because of daycare or someone has COVID, or 602 because the employer closed down or had reduced hours. So if it's a 602, the employer goes first to explain what happened. After whoever goes first and explains, the other side has a right to ask questions of that person. So you want to prepare your questions for what your issue is. What was the reason for being severed? You want to have them ahead of time. And the questions have to start with what, why, where. It's not an opportunity to make statements. You'll have an opportunity to make statements as soon as the other side's done, and then the administrative law judge will ask you what happened. Then, after all the testimony has been done and the cross-examinations have been done, the administrative law judge will then ask each party if there's anything to add. You can either add more facts if you think something was missed, or you can do a closing argument. You're entitled to open and closing. I wouldn't bother unless you have a complex issue. Most are not complex, but that's up to you. You can ask for an opening and you can ask for a closing. Okay. After that, the administrative law judge will then close the hearing and let you know that they're going to issue their decision shortly. Typically, the decision was mailed out the next day. That's not to say that in the past, administrative law judges have taken additional time to issue their decision. Okay. Once you get your decision, that sets forth whether the claimant is entitled to benefits or not. If you disagree with that decision, then you can appeal to the Board of Review. That form is online to appeal to the Board of Review. How the process works is you're going to need a copy of the transcript. You're going to have to order it, and you have to pay for copies of the transcript. Once you get the transcript, you're going to have to write a brief. You're going to have to set forth the law, why it's wrong. For the most part, this process is a little complex or very complex for parties to do. you may want to hire an attorney to do that, but that's your option. There's no requirement that it be done by an attorney, but there are a lot of rules that you need to follow. The Board of Review will then get briefs from both sides, and then they will issue their decision. If you don't like the Board of Review's decision, you can then file an administrative review in the county at which you reside. There's no fee currently for administrative reviews, and there hasn't been a fee for the last 30 years. You need to follow the process. This is now even more complex than the Board of Review, and I would strongly suggest you hire an attorney, but you're not required by law to have an attorney. You need to serve the state. The state will then file their answer, and then a briefing will be written. You'll have to write whoever filed the appeal why they disagree with the Board of Review's decision. The administrative law judge actually looks at the appeal decision on whether the administrative law judge was right or not. That pretty much is what needs to be done for the process after the local office determination. Please make sure that anything you file is within the 30-day statute of limitations, or otherwise it's a final decision. And just a little note that if you were a claimant and you were receiving unemployment benefits and there's a determination that you're not eligible for benefits, you have to pay that money back to the state. If you ignore it and you don't pay it back, when you file for unemployment next, they will recoup their money from that unemployment benefits. They have a whole bunch of processes that they can recoup that money, but that's probably the biggest. And I find years later when someone's unemployed again, they then file for unemployment benefits and they're shocked to find that they're not receiving money because of that. Hopefully that's helpful. If you have any other questions, you can call us or write us. It's jeffjacobsonlaw.com. Thanks.